Count 1, murder in the second degree. Verdict. We, the jury, finds as follows. The defendant is not guilty. So say we all this 25th day of February, 2022, juror number 2, foreperson.
Of course, any conviction is life in prison for this guy.
In the courts of the 6th Judicial Circuit in and for Pasco County, Florida, State of Florida versus Curtis Jetson Reeves, case number 2014 CF 216 CF AXES, information 4, count 2, aggravated battery. Verdict. We, the jury, finds as follows. The defendant is not guilty. So say we all, this 25th day of February,
What about the lesser included charges?
Juror number 2, foreperson.
Thank you, Madam Clerk. Does counsel for either side wish to poll the jury?
That's it.
All right, ladies and gentlemen, at this time, the deputy clerk will poll the jury. That simply means that she will ask each of you individually
Lawful
if the verdict she
self-defense
read
is the
your
verdict,
verdict.
folks.
If it is, you need only answer yes. If it is not, of course, you should answer no.
I wonder what
Madam
the law
Clerk,
and
will you
crime
please poll the
commentary
jury?
is doing.
Juror number 1, is this your verdict?
Yes.
Juror number 2, is this your verdict?
Yes.
Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict?
Yes.
Juror number 5, is this your verdict?
Just letting
Yes.
Nick know.
Juror number 6, is this your
I
verdict?
invited Nick
Yes.
to join me, but he
Thank
wasn't
you,
able
Madam
to.
Clerk.
There we go. 8 years since this event happened. On the legal
All
merits,
right, Mr. Reeves,
it was
jury having returned a verdict of not guilty as to count 1 and count 2, you are free to go. Congratulations, everyone.
Free to go.
Thank
Free
you
to
for
live
a
the
wonderful
the remaining 5 years of his life.
time.
A free man,
Good luck.
acquitted within hours. That's how much merit there were to these charges, folks. You saw my analysis from the first day I was writing on this case. Within 24 or 48 hours after the shooting occurred, called it as likely lawful self-defense. Didn't see the prosecution overcoming self-defense beyond a reasonable doubt at any point in this trial, including when the state rested. It only got worse for them from there. The only hope the state had was, I hate to say it, the very, very weak opening and closing arguments by the defense here. The defense team very nearly ripped defeat from the jaws of victory, and this man's life was at stake. It was terrible. That closing was a train wreck for the defense. There was no story arc. There was no focus on the elements of self-defense. There was a meandering swamp of 3 hours of closing dialogue that really put their client at risk of being sentenced effectively to life in prison. But nevertheless, the jury saw the truth. The jury saw that the state had not disproved self-defense beyond a reasonable doubt. And they returned a verdict of not guilty on both the second degree and the aggravated battery charges.
All of the testimony and the physics of it and the forensics of it support the fact that Chad Olson is turned around in his chair, standing up in a movie theater over Curtis Reeves. So you say, was he standing up politely, sitting back from his chair? How would that be possible when he's grabbing the popcorn? The guy is imposing on Curtis Reeves' space. Curtis gets hit in the head. After that hit in the head, Chad Olson doesn't stop. He's still in the space. In fact, he's going to reach in again and throw the popcorn. Is it reasonable to think he's going to get hit again? Of course it's reasonable to think he's going to get hit again. He was just hit. This guy's moving at him. He's erratic. He's leaning over into his space. Focus on the facts present at the time. CS says, it scares me. All the people focused on Curtis asking people to turn their phones off when Olson was literally physically abusing an elderly man for that.
Boomer, wow, no excuse for elder abuse. Hard to disagree with that. And I'm just wondering what the commentary on Law and Crime looks like. Insane. I was wrong. I'm in total shock. You know why? Because they're stupid. At least on use of force law, they're stupid. They got it wrong, profoundly wrong. When a jury returns a verdict this quickly, there was really never any doubt in their minds, any of their minds.